The first thing to note is there are different categories for tax debts, and I'm going to simplify things rather than going agency by agency and just say some tax debt is secured, some tax debt is what's called priority tax debt, and some debt is non-priority tax debt. Secured tax debt means the taxing authority, and let's just focus on the IRS, the principles are similar with the others, has a lien against your assets. And sometimes the IRS will record a lien against, say, your real property, and you want to make sure that they've recorded it in the right county, because if it's not recorded in the right county, it's an unperfected lien. But there is something known as a secret lien that the IRS has that's by statute, where the IRS has a lien against all of your possessions. That kind of a debt is not going to be discharged in bankruptcy, generally speaking, with an exception that I'll get to in just a second. So that is a secured tax debt that's secured by tangible assets that can be seized by the taxing authority in the event of default. In the realm of unsecured debts, meaning there is no collateral behind them, Congress, in its extremely finite wisdom, has seen fit to distinguish certain kinds of unsecured debts as getting special treatment. They're called priority tax debts. The rest are non-priority tax debts, and they're unsecured. Well, the priority tax debts will not be discharged in bankruptcy. Sorry, thanks for playing. They're not going away. The non-priority tax debts can be discharged. So what do I mean by that? Well, you go through a bankruptcy, those debts will be wiped out, provided they satisfy the requirements for discharge. And what you want to keep in mind in this analysis is 3 to 240. That's what has to be satisfied. Let's start with 3. This is the 3-year rule. What it says is the tax return for the given tax year or the given tax period must have been due, with extensions if you got them, at least 3 years before the day you file your bankruptcy petition. And if you're off by even 1 day in any of these, you lose. So you take a look at the due date, add 3 years and a day, and you're okay on that score, unless you got an extension, in which case you have to add more time. Now you'll notice the wording here. The 3-year rule looks at when the tax return was due. It doesn't say you actually filed a return, just when was it due. The second requirement, the 2-year rule, says you must have filed a legitimate, non-fraudulent return for the given tax year at least 2 years before the day you file your bankruptcy petition. Now, there's been a fair amount of litigation over what it means to be a legitimate tax return. Sometimes people will file their returns late, and in some parts of the country, that's not considered a tax return for bankruptcy purposes. So generally speaking, file your returns on time. Sometimes a person just won't even get around to filing, and the IRS will file a return on that person's behalf. That's what's known as a substitute for return. In tax lingo, it's an SFR. When that happens, that is never going to be a return for bankruptcy purposes, and that tax debt you're never getting rid of in bankruptcy. But if you file the return and at least 2 years and a day have elapsed since you filed the return, then you've satisfied the 2-year rule. So we've done the 3-year rule, the 2-year rule, and now the 240 rule. That's 240 days. The tax you're seeking to discharge cannot have been assessed during or been assessable in case the return has been audited during the 240-day window immediately prior to the day you file your bankruptcy petition. 240 is 8 times 30, so it's 8 30-day months. Yes, 8 30-day months. Sorry, there was an unnatural pause there. So if you can satisfy all 3, then your tax debt is going to be dischargeable. Now, as always, there are a couple little wrinkles. Suppose you filed a prior bankruptcy case and the time of the ticking of, let's say, the 240-day clock coincided. Well, when you filed that bankruptcy, the clock stopped ticking. And you have to wait until that bankruptcy is completed, the case is closed, then you restart, and then you have an additional 60 days. And then 60 days on top of finishing up that 240-day clock, if that's the clock in question. And then you will have satisfied the 240-day rule. And similarly with the 3-year and 2-year rules. Similarly, if you were in an offer in compromise, that's not bankruptcy. You're dealing directly with the taxing authority and you've entered into a special kind of repayment program called an offer in compromise. That also tolls the ticking of those clocks. So once the offer is done, maybe it was dismissed and that's closed, then you restart the clock, but there you have to add an additional 30 days. So if you've satisfied all those requirements, then that unsecured non-priority tax debt is dischargeable in bankruptcy. Now, I said that there was a little bit of a twist in dealing with secured tax debt. Suppose the IRS has a lien against your assets, so it's a secured debt, but the underlying tax satisfies the 3-year, 2-year, 240-day rule. Then your personal liability on the tax will be discharged in the bankruptcy. There still is that lien against the assets, but you are not personally liable on it, meaning the IRS can't come knocking at your door and demand that you pay. And you don't want the IRS knocking at your door because if that happens, you've got much, much bigger problems than just the tax debt. So in that situation, sometimes once you get your discharge and the case has been closed for at least 30 days, you can call up the IRS lien office and say, you know, this debt was discharged. Would you release the lien? And sometimes if you're really nice, they'll say, okay, and we'll release the lien. So in that very special situation, you might be able to get rid of even that secured tax. Now, that's all thinking in terms of Chapter 7 bankruptcy. In Chapter 13 and in Chapter 11, things are a bit different. The secured tax debt, it doesn't matter whether it's dischargeable or not. You're going to have to pay that in full, at least to the extent that the debt is secured. You're also going to have to pay the priority tax in full. The only portion of the tax that you might not have to pay in full is the non-priority unsecured tax debt. Tax debt has to be paid in a Chapter 11 within 60 months of the day you file your bankruptcy petition. Notice that's not 60 days from the date that the plan of reorganization is confirmed by the court, but 60 days from the day you file the petition. So if it takes a while to get that plan confirmed, you're going to have a shorter time window to pay the tax debt. So kind of complicated. As a matter of fact, there's a whole world of tax and bankruptcy that's implicated here. And I have to confess that I have really only scratched the surface. But for the ingenue that's asking this question, I think we've plumbed it as much as is necessary.